Morning, Council. This is the case of Porenta versus Porenta. And Justice Himonas, as you can see, is recused on this matter. We are pleased to be joined by Judge Mortensen of our Court of Appeals. Council, please enter your appearances.
Stephen STARR for Appellant, Louise Porenta.
Mr. Starr, welcome.
Thank you.
Jennifer Lee representing the Appellee.
Welcome to you, Ms. Lee. I see you're reserving 5 minutes. Let's start.
Yes. Good morning, Chief Justice and Justices of the Supreme Court. May it please the Court. Appellant in this case asked this Court to reverse the trial court's finding of a fraudulent transfer between husband and mother because there was no debtor-creditor relationship at the time wife filed her fraudulent transfer claim, because any debtor-creditor relationship that existed between husband and wife in the underlying divorce case terminated upon husband's death and subsequent abatement of that divorce case.
Well, counsel, let me ask you, I understand that that claim that the debtor-creditor relationship abated was because the interlocutory orders with respect to child support abated when the divorce action abated. But there still exists a relationship between husband and wife in which they owe each other reciprocal obligations, and they owe each other, they each have a claim on any and all of the marital property. That there may not, those claims may not always be valid. But isn't that sufficient to satisfy the act?
No, Your Honor, I don't think so. I think what we need to do is distinguish how we're defining the word claim. The Uniform Fraudulent Transfer Code specifically defines it as a right to payment.
Well, but that's exactly my point. You have, as a tenant in common, for example, in real property, you have a right in the event of the death of the other tenant.
Your Honor, are you talking joint tenant or tenant in common?
I'm sorry, aren't they tenant in common here?
The husband and wife own the
Or
property.
tenants by the entirety? What were they?
Originally, the husband and wife owned the property as joint tenants with rights of survivorship.
Right.
Upon transfer of that property, that severed that joint tenancy. And then mother owned the property with...
Yeah, but that's my point, is that if you go back to the point in time when they were joint tenants, if the severing was in fact part of a fraudulent transfer, then you've got property right in the surviving tenant.
Your Honor, again, the purpose of the Uniform Fraudulent Transfer Code is to satisfy a claim or a right to payment, not to make property distributions. Additionally, I would argue that a joint tenant, whether married or not, has the right to sever the joint tenancy at any time without notice or approval or consent of
Well, but that's true outside the context of a divorce. Once a divorce action has been filed or is contemplated, it's arguably subject to the Fraudulent Transfer Act.
Your Honor, if I may, there is case law that allows for transfer, I don't say allows for transfer of property. It's Hamilton versus Hamilton, decided by this court in 1977. It's 562 P2D 253, and this is an answer to your question. What the court said was Title 30, Chapter 3, Section 5, Utah Code annotated, which is about divorce and distribution of property, gives the court, with a decree of divorce, when a decree of divorce is made, the discretion to make such orders in relation to property as may be equitable. It neither authorizes nor prohibits a party to a divorce action from transferring assets during the pendency of the proceedings. The statute specifically sets forth the stage of proceedings at which the court may exercise its discretion, and that is when a decree of divorce is made.
But the district court here held that the plaintiff's claim against the defendant at the time of the transfer encompassed the whole of the marital estate, including the right to preserve the joint tenancy. Now, that, I take it, is part of what you're challenging on appeal, right?
Yes, Your Honor, because I would again argue that in that context, the word claim is not a right to payment, it is a demand for something. And if a claim is not satisfied, then it becomes a lawsuit. So her demand or her claim for the whole of the marital...
And what's your authority for that interpretation of the word claim?
Well, specifically in the Utah Fraudulent Transfer Act, it does define claim as right to payment. I don't think every time a lawsuit is filed, they're asking for a right to payment. So I think a general definition would be a demand that, if not satisfied, can turn into a lawsuit.
The definition, however, expressly defines it as whether or not it's been reduced to judgment, and also defines it as being unliquidated. So it isn't a payment that's certain. I mean, that's the definition of an unliquidated claim, right? Something that hasn't been reduced to judgment, hasn't even been sued upon, but could be.
Yes, Your Honor, I think that's defined that way to allow for initiation of a lawsuit. However, if it is a right to payment, one would have to prove the value of that right to payment as the creditor. What is the dollar value of that payment? You can't just go into court and say, he owes me money, and then when asked how much, say, Mama, I don't know. It's sufficient to start a lawsuit to attach, I guess I'll say, a fraudulent transfer claim if need be, but ultimately, the creditor will have to prove how much money this debtor owes him or her.
If there is a claim that still exists that wasn't abated by the divorce, might it be a claim involving the husband's estate?
Yes, Your Honor, it would be, and in fact, Appellee even admits that in page 11 of her brief that the claim, the demand now resides with the husband's estate. And if I'm not mistaken, she filed a claim with the husband's estate. That claim was denied by the personal representative.
Who's the mother, right?
I'm sorry?
Isn't the mother the personal representative?
Yes, she is.
Right.
And then,
No surprise there.
and then,
But there's further recourse for that, I assume, in probate proceedings?
yes, Your Honor. And she pursued that. Her claim was denied, and she failed to attempt a judicial review of that claim before the time expired in the probate case. So while she had an avenue of recourse, or she had some sort of approach to remedy, it's no longer available as well.
What did that claim look like? Was it a claim for fraud? I mean, if there was a claim against the husband for fraud, would that claim survive his death, and would the estate be liable for the husband's fraud if that could be proven?
The claim filed in the probate case, Your Honor?
Yeah.
I'm sorry, can you repeat your question?
I'm just wondering about the nature of that. Maybe it doesn't really matter. I'm just trying to understand how this would fit. Because, I mean, at some level, this feels sort of unfair, right? And I think that's kind of the tension here. We've got pretty solid arguments in terms of the language of the statute on your side, and apparent inequity on the other side. And one possible response to that is, well, the inequity could have been remedied by a claim against the husband's estate, that they just lost the ability to pursue that claim. So that's partly why I'm trying to understand the nature of the claim. Maybe it doesn't make a big difference.
I would agree that if there is an inequity, it could have been remedied in the probate estate. I don't know if it was brought out.
Well, how could that be when the husband had transferred it out of the estate? The estate had no interest whatsoever in the marital home.
I assume that's why the probate claim was denied. I do not know.
Well, this is why I'm asking about the nature of the claim. One possible response to Justice Durham's question, I would think, would be, well, if there was a fraud on the part of the husband, and if an estate, I don't know how this works, I don't remember, but is that the kind of a claim that survives death? If so, maybe that's how you bring the husband's estate into it, by claiming that the estate has a responsibility for his fraud. I don't want to derail too much the discussion, but that's the point of my question.
And I'm not a probate attorney, Your Honor, but I know that her claim or her right to payment was based on the divorce action. Now that the divorce action is no longer, she can't sue for divorce. She can only go to the probate estate and try to remedy that situation.
Well, not if there is no interest in the probate estate. I mean, that's what my question went to. And, well, I appreciate your assertion. I understand it.
Thank you, Your Honor.
What about the judgments? Is it your position that the judgments on child support that had already entered abated?
Your Honor, they were termed judgments, but technically they were temporary orders in a divorce case.
Well, the temporary orders say that you have an ongoing obligation to pay child support. However, there had been a hearing, and in that hearing, I thought your brief conceded as much that as to at least the amounts of those orders that had actually been reduced to judgment, those did in fact constitute judgments, did they not?
I don't think they were reduced to judgments, Your Honor. Rule 54 of the Utah Rules of Civil Procedure define what a judgment is. It is,
Well, your brief says on page 18, some of these judgments were even recorded in the Registry of Judgments.
that's what the trial court found, Your Honor, but they were temporary orders. And again, Rule 54C of the Utah Rules of the Civil Procedure, if I could invite the court's indulgence for a second so I can find what I'm looking for. It defines a judgment as a decree or any order from which an appeal lies. I have never seen a case where temporary orders in a divorce case are appealable because they're temporary. They can be amended by the court, or they can even be negotiated away by the parties if they try to settle out of court.
Does this even matter? Because even if they were final judgments in some respects, they're not enforceable as against a dead person, so
That
they're
is-
enforceable if at all, and I don't know how this works, but they're enforceable if at all only against the estate, and the estate is not a party to this proceeding.
Well, and nobody's trying to enforce them.
I'm sorry, Your Honor, what was your question?
And no one is trying to enforce them. They are not at issue in this appeal.
That is correct, and I agree with you, Justice Lee, that whatever happened in the divorce case abated, even if they were judgments. She cannot go back to the divorce court to enforce them with an order to show cause.
Right, so then the only question would just be, does that liability pass to the estate?
I guess it would, yes, Your Honor. And with your statement, no, I don't, the estate is not part of this case, and she tried to file a claim with the estate. That claim was denied.
Not with respect to any of these judgments or orders.
I'm sorry?
Did she attempt to file a claim with the estate pertaining to any of these judgments or orders?
I do not know specifically what she filed with the estate. I'm assuming
It's not been asserted that she did. The only assertion anywhere has been by you here today that she was going after the interest in the real estate.
And I assume that's what she did in the probate estate. I do not know.
So basically, we have no record and nobody knows what's in the probate.
Correct.
Thank you.
Can I ask you about your interpretation of the Uniform Fraudulent Transfer Act? Under your reading of the act, is there ever an instance where a creditor could obtain the fraudulently transferred asset?
Your Honor, the answer to that question will take a moment to explain, if I can invite the court's indulgence again. To answer that question, we need to understand there's between void and voidable. And this court addressed that issue not too long ago in a case called Bank of America versus Mortensen, I think it's 2017, Utah 2. Void is defined as not valid, cannot be ratified, cannot be agreed to, has no legal force and effect, it's completely null. Anybody can attack a void judgment or a void document or a void whatever at any time in court. Voidable means it is valid to the whole world, and the only person who can attack its validity is the injured party. And the injured party can, if he or she wants, can ratify that action and make it valid. So as we apply it to the Uniform Fraudulent Transfer Act, the transfer between the debtor and the transferee is a valid transfer. Neither one of those parties is injured by that transfer. So they fall within that realm of the whole world is valid too. The creditor, on the other hand, is the injured party. The reason she's the injured party is because she was relying on the debtor to have ownership of that property so that the creditor could eventually get a judgment and then levy and execute against that property to satisfy her right to payment. Now that there is no property for the debtor to, for the creditor to attach to, there's her injury. So she goes to and files a fraudulent transfer claim. Fraudulent transfer statute says she can receive avoidance or can obtain avoidance of the transfer to the extent necessary to satisfy her right to payment. In other words, what she can do is obtain a ruling from the court saying, yes, the transfer is not valid as to you, creditor. It's still valid to the debtor and the transferee.
But that's exactly what the trial court did here. Said that the transfer may be avoided.
Well, Your Honor, I'm arguing that it means that it's declared not valid as it relates to the creditor.
Right.
So now that it's not valid as it relates to the creditor, what are our remedies? Well, we can't undo the transfer because it's a valid transfer between the debtor and the transferee. It's valid as to the whole world except the injured
Well,
party.
there is the nub. The trial court held against you on that question under the Uniform Transfer Act, or the Fraudulent Transfer Act. And I'm trying to understand how you connect that position to what's in the act itself.
I'm saying that the trial court misinterpreted what it means avoidable. It means just being declared not valid as it relates to the creditor.
So what if there was a claim that was valued for a greater amount than the value of the property? Then avoidance of the transfer to the extent necessary to satisfy the claim wouldn't mean rescind the transfer period?
No, Your Honor. Because if we go to 2569, what it says is the creditor may recover judgment for the value of the asset transferred or the amount necessary to satisfy the creditor's claim, whichever is less. And the judgment may be entered against the transferee or a subsequent transferee. And so that's what I was getting at. Now that we have an injury to the creditor, the transaction between the debtor and the transferee is injurious to the creditor. What's our remedy?
So there it talks about a judgment. Here in 1A, it's talking about avoidance. So what does avoidance mean in your view?
Again, it means it's not a valid transfer as it relates to the creditor.
So
And
you equate it with voidable, but I'm not sure that avoidance of a transfer has any statutory or linguistic connection to the voidable distinction.
Your Honor, if we look closely at the statute, the word avoidance comes in section 25.6a, sub 1, sub a. If we go to 25.6.9, what it says, and I'll just read it in its entirety, 25.6.9, sub 2, except as otherwise provided in this section, to the extent a transfer is voidable in an action by a creditor under subsection 25.6a, sub 1, sub a, which uses that term avoidable. Basically, what the statute is doing is defining for the statute what avoidable means, and it means recovered judgment.
But in your view, does 2569 apply outside of a good faith purchaser for value?
Yes, yes. In fact, it does say 25.692 sub b. The judgment may be entered against any subsequent transferee other than a good faith transferee who took for value or any subsequent transferee. So if you're a good faith transferee, you cannot have a judgment obtained against you. And the reason we have a judgment as the remedy is because before all this happens, the creditor can get a judgment and levy and execute against the debtor. Now, the creditor can get a judgment and levy and execute against the transferee. It creates that privity between the creditor and the transferee that wasn't there before. It basically pierces the title of that transaction and says, I'm a creditor, I have some rights that need to be satisfied by the debtor. I didn't have any rights against the transferee before, but now I do in the form of a judgment. Same judgment I would have had against the debtor, except now it's against the transferee because he has the property. And I would also argue that if the transferee likes the property that he had, he could satisfy that judgment with some other means. Maybe he transferred it to his rich uncle. His rich uncle says, you know, there's a judgment for $25,000, I'll just write you a check, I get to keep the property, because that transfer from the debtor to the transferee is valid against the whole world, and the debtor and the transferee are part of that whole world.
So avoidance of the transfer really means a lien against the property?
It could be, or the statute specifically defines it as a judgment against the transferee, substituting the transferee now for the debtor that used to be there. Your Honor, as I see I'm out of time, if there's no more questions, I will yield the podium.
Thank you, Mr. Starr. Ms. Lee?
Thank you for the opportunity to address you today.
Ms. Lee, before you get started, I wonder if I could follow up on Justice Lee's question about the claim against the estate. Was a claim made in the context of, with respect to the estate, that the estate should include the husband's interest in this property because it had been fraudulently transferred?
There was not that claim, Your Honor. Let me explain very briefly what the claim is. Okay? The claim is a claim based on the marital interest, the interest that my client accrued in the marital property during her marriage.
You're saying the claim in this case?
In this case.
Can I follow up on the Chief Justice's question first, though?
Yes.
Why didn't, maybe you weren't involved, but why didn't your client make a claim in the probate proceedings for fraud or to try to get the interest in the property within the estate?
she did make a claim in the probate case.
Uh-huh.
It was denied. But what she can get in the probate case is extremely limited compared to what she was claiming as her marital interest.
What was the nature of the claim
Okay.
in the probate proceeding?
Okay, in a probate proceeding, as we know, she can only get a spousal election. Okay, she had been disinherited by her husband, by his will, which means all she can get is a spousal election, which is 1/3 of what's in the estate.
Could she not have asserted a fraud claim?
She could have asserted a fraud claim, but again, that would get her 1/3. Okay, there would be a clawback. She'd still have to assert the same fraud claim that she brought here, and it would still give her only 1/3.
But why isn't
of
that the
assets.
answer to the apparent inequity here? That's,
Okay.
now I know you'd rather have more
Part of
than a
it-
third, but if that is available to her, and if there isn't a claim that is pending as of the time of the filing of this fraudulent transfer act case, I think you may be in
It-
trouble.
It wasn't pending at the time, Your Honor. And part of it is inherent in the definition of marital interest, okay? As we know, marital interest is an equity decision, okay? It's not an assumption, it's 50% of what is there asset-wise. It's based on what are the debts of the marriage, what's the fairness of it, who's going to raise the children, how did you get these assets, a lot of other equitable considerations, okay? My client was claiming a marital interest in the whole of the marital estate through
And that's a claim against whom?
that was a claim against the husband.
Right, which abated when he died.
No,
Not,
Honor,
not in
that's where
connection
I
with
would-
the marital estate.
So
That's
so
where-
once he's dead, who's that claim against?
okay, the claim is against the husband. Where I'm saying no, Your Honor, if I could just explain.
Sure.
The divorce abated, okay? The cause of action for termination of the marriage abated. That's what was dismissed, was the cause of action for termination of the marital relationship, not the claim. The claim is different. The claim continued.
Okay, and against whom?
It would then be against the estate, because of course he's dead.
Which is not a party in this case. The estate's not a party here,
in
and that's
this
the
case.
problem I'm having. I wonder if you
That's
can
why-
explain why that isn't a problem.
Well, and that's why the case was, well, you bring the suit against who's got the property, the party in interest. It was brought against the mother-in-law. And that's where, Your Honor, we call upon the language in the Bradford case, that the statute is to be construed to reach all artifices and invasions designed to rob the act of full force and effect. As we can tell from the findings, the facts that were submitted in this case, and the record. The mother and my client's husband, together with the attorney, had worked together to do this transfer of the home, partial transfer, to sever the joint tenancy, to transfer half of the value to his mother. In the opinion of the district court judge, the findings reflect to ensure that the attorney would be paid at the same time as disinheriting the wife. It was all an artifice and invasion to deprive my client of her marital interest. Even with probate law and the spousal election, there was no way my client could get what she was entitled to, that she could get her claim. She still had that claim. The definition of claim in the Fraudulent Transfers Act says even if it's disputed, even if it's not liquidated, even if it's equitable. And we believe it survived his death. It survived the dismissal of the divorce case. That's what was presented by the appellant as the issue before the court today, is whether or not there was still a claim. Because without the claim, there's no creditor-debtor relationship.
And I may be completely wrong on this, but I was trying to think about this in a different way than I have been thinking about it. Now, if he had not died, once the wife became aware of this transfer, certainly she had a claim against him. Would she not have also had a claim against the mother at that time?
She would have.
As the beneficiary of the fraudulent transfer?
She would have at that time, but it was already in the divorce case. The divorce court had already reserved the issues of the house and the allocation of the house for trial.
Yeah, I guess just what I'm wondering is, even if whatever claim she had against him now must be asserted against the estate, she failed in that respect. Whether that necessarily affects her direct claim against the beneficiary of the alleged fraudulent transfer, the mother.
I don't know, Your Honor. That's never been asked of me before. I don't know.
Well, to follow up on the Chief's question, I mean, maybe a way of framing it, is there anything in the Uniform Fraudulent Transfer Act that requires the debtor to be brought in and be a party? Does the Uniform Fraudulent Transfer Act allow a direct action against the person who received the disputed asset without naming the debtor?
There's nothing, no, Your Honor. There's nothing that prohibits it. There's nothing that specifically agrees.
So it's not specifically addressed in the statute?
There's nothing not specifically addressed.
Let me ask you about the provision that I think is the basis for Mr. Starr's argument, and it's 25-6-8-1A, and it gives the right of relief of avoidance of the transfer or obligation to the extent necessary to satisfy the creditor's claim. So what claim is at issue that avoidance of the transfer is necessary in order to satisfy that claim?
Okay, the claim that's at issue is the claim to the interest in the house.
Right. Against whom? And that's what I keep coming back to, because it can't be against the husband anymore because
No.
he's deceased.
It's,
And it really can't be against the estate because
Okay.
you failed to assert a claim against the estate. So that's where I'm getting stuck.
it's
Well,
the
the estate
claim
doesn't have
for
any, again, the
avoidance.
estate doesn't have an interest in the house. The mother
No.
is the only one with an
Right.
interest in the house.
Yes, it was a,
But doesn't there, under this subsection 1A, doesn't there have to be a claim against someone
yes.
for whom the avoidance of the transfer is necessary in order to satisfy that claim? That's where I'm getting
Right.
stuck.
The claim was against Robert Porenta. Okay. Fraudulent Transfers Act was based upon the creditor-debtor relationship between my client and the husband.
Right?
The fraud was the transfer. The fraudulent transfer was the transfer of the home to his mother.
Right.
Okay, and so the suit was based on the fraudulent transfer and that the mother was the recipient of the fraudulent transfer. And that was undisputed.
Right, but that claim is abated. right? I mean, you can't have a claim against a dead person. The question then just becomes, is there a claim that succeeds to the dead person's estate?
Well, but the claim to the marital estate survived in terms of the divorce proceeding, and the abatement of that, it seems to me, that doesn't abate the claim to the marital estate. They're still married once the divorce proceeding has gone away, are they not?
I don't believe well, it's till death do us do part.
Okay, so
I don't believe they're still married.
but they're not unmarried.
But there is.
Their estate has not been severed, I guess.
Right.
I guess is the.
But to have a claim, don't you have to have someone against whom the claim is being asserted? And if the husband, which is the initial person against whom the claim is asserted, is dead, then the only possibility is the estate. How do you have a claim without a defendant?
You have, but Your Honor, we're all familiar in the rules of civil procedure with what we do when we have a case, we have a claim against someone, and the defendant dies. You do a substitution, and it goes against the estate. So there's still a claim. It goes against the estate.
But that didn't happen here, right? And that's the problem. That's why
Well,
I keep
whether or
asking
not
you
it
about the
happened-
probate proceedings, because it seems to me that you're conceding that you could have but didn't bring a claim in the probate proceedings for fraud.
Well, we didn't bring a proceeding for fraud, but, Your Honor, I would submit, does that mean we didn't have a claim?
Well, that would be the place to assert that you did, I would think.
Okay, but the issue, Your Honor, that has been raised by the appellant is that there was not a creditor-debtor relationship, and therefore could not be a claim under the Fraudulent Transfers Act. Okay, there was not a creditor-debtor relationship because there was no claim. Just because, arguably, there was not a claim under the Fraudulent Transfers Act does not mean that there was not a claim by my client, that there was not a creditor-debtor relationship between my client.
So who's the debtor then?
Husband.
Maybe that's the better way to put it.
The debtor
To have a claim,
is
you gotta have a
still-
debtor,
it's
right?
his estate
Right.
standing in his stead. So there was still a fraudulent or a creditor-debtor relationship that would sustain a claim under the Fraudulent Transfers Act.
Well, the way the trial court put it, and let me just ask you if this is the way you think it works. The trial court held that if not for the fraudulent transfer, the joint tenancy would not have been severed, and plaintiff would have become the sole owner of the subject property upon Robert's death. So plaintiff's claim at the time of the against defendant, meaning the mother, at the time of the transfer encompassed the whole of the marital estate, including the right to preserve the joint tenancy or require the husband to convey his interest free and clear to the wife. The joint tenancy itself was a marital asset that husband could not unilaterally dissipate while the divorce was pending. And then the trial court also held that the problem was that the husband, he held that the mother was an insider and that the husband at the time of the transfer was insolvent and unable to pay the obligations that he owed the wife, which I gather the trial court felt included the joint tenancy value. Is that how you understand it as well?
Yes, Your Honor. If I could also just very briefly, there was a question that was asked as to whether or not there had been a case where a transfer had been voided. I would point out that, yes, there was, in the Bradford case, which I cited in the brief, Bradford v. Bradford, in that case, which was a fraudulent transfer case, in a divorce, a spouse had transferred, had severed a joint tenancy, and had transferred an interest to a family member, and the court came to the conclusion that the transfer was therefore void and restored the joint tenancy title in the home, undoing the transfer. There was also,
But
though,
did Bradford actually address the question presented here, whether the act provides for that? It didn't appear in Bradford that they actually discussed that question. Couldn't they just assume that it worked the same way the Fraudulent Transfer Act always had, and nobody made the argument that's being made today?
nobody made the arguments that I hear today, just very
Was it
simply.
decided under the older fraudulent transfer act or the
Okay.
the new one?
Okay, the new one, the Voidable Transactions Act that was just
25-1-15.
passed? Okay, there was,
The other side makes the argument that under the old fraudulent transfer act, it's clear that you had the remedy of setting aside the transfer,
okay,
whereas under the new one, the language of avoidance suggests
okay,
that that's not necessarily the case. And I'm asking
okay.
under which act Bradford was decided.
Well, let me address that a little bit, Your Honor. First of all, there's the current version, as it is right now, of the Uniform Fraudulent Transfers Act has been in effect since 1984. And Bradford was under the 1984 version, okay? And they did void the transfer. There's also, under the 1984 version, the National Loan Investors versus Givens case, which was not a divorce case at all. That was a case authored by Justice Stewart where the property, it was again real property, had been transferred by Givens to third parties. And National Loan Investors brought this case under the Uniform Transfers Act, and the remedy was that they voided all of those transfers and put the property back in the hands of Givens so that National Loan Investors, when and if they did get judgments, would be able to execute those judgments against those properties. So they voided the transfers. There's not this tortuous difference between voiding and avoiding or whatever. Your Honor, I'd also just point out in the Act that Section 2568 lists very clearly, here are the remedies. And it says number one is avoiding the transfer. Avoiding the transfer. You have to find the language about granting judgment instead in 2569. In both instances, it says the court may avoid the transfer. The court may grant judgments. May, in the form of elections, options. Court's given the discretion, which makes perfect sense. The Fraudulent Transfers Act is intended to give remedies that are equitable. Look through all of the case law. You look at this is a law that it goes back to 1570 in Old England. Its remedies are equitable as well as legal. the idea of specific damages, where money damages are inadequate, is an equitable remedy. It always is applicable when it comes to something where you're talking about something as personal as someone's home, which is what we were talking about here.
Counsel, I need you to wrap it up. Your time has expired.
If there are no other questions, I have nothing else.
Thank you. Thank you, Ms. Lee. Mr. Starr, if I could start you with this. So this goes to your voidable argument. Under 25-6A-1A, which we focused on avoidance, it seems to me, and correct me if I'm wrong, that you're effectively arguing that what that really provides is the opportunity to attach property and obtain money damages.
For the creditor, yes, Your Honor.
Yet that very option is made available in subsection B, an attachment or other provisional remedy against asset transferred. I mean, why doesn't that suggest that in using the term avoidance, the legislature meant something different
Your
than
Honor,
an attachment?
the answer to that question is if you look at the remedies provided for, there's A, B, and C, and they're in a sort of a hierarchy type of structure. The remedy under A is the ultimate remedy provided at the end of the case. Subsection B talks about an attachment or other provisional remedy. Provisional means providing or serving for the time being only, existing only until permanently or properly replaced. It means temporary. So B is a temporary remedy, the strength of which is where the court can take control or possession of that property. Attachment means the court can take control of it. As we go down our tier, letter C is, and I'll go back to B again real quick, Your Honor. B is a pre-judgment remedy. A is a post-judgment remedy. B is a pre-judgment remedy, and C is also a pre-judgment remedy, less effective than B. It allows the court to control the property by an injunction or by someone taking charge of it. And C, where it's and C sub triple I, any other relief the circumstances may require would involve don't devalue the property. If it's a car, don't put more miles on it. If it's a piece of land, don't mine from it anymore because the value of the land is
Well,
considered.
that's a pretty broad clause that I hadn't focused on. Any other relief the circumstances may require. Why would that not include voiding the transfer?
Because I would
ordering the
argue that
property returned?
subsection C is a pre-judgment remedy, because we're talking about an injunction, which would be during the case.
Well,
But-
that's a little lie, an injunction. The heading C, I mean, you may be right, but explain to me why that's necessarily confined to a pre-judgment remedy when subsection C reads, that doesn't seem to limit it in that way.
Well, subsection B, I think, is definitely a pre-judgment remedy because it uses the word provisional.
Yes.
And the strength of that is the court taking control of the property.
Right.
Subsection C is less weak or is weaker than subsection B. It just allows the court to control the property. And so if we look at it from that point of view, there again, that hierarchy, that three-tier structure, if any other relief of circumstances was a subsection delta D, then it would have more weight. But I think because it's placed under C and it's the third element under C, which again I'm arguing is a pre-judgment, very weak remedy, it only applies to the property to not devalue the property because that's what the creditor's looking for, the value of the property. Again, her claim is a right to payment. If she can attach to the property and get that payment, that's what she's looking for. The value of the property goes down, she's not getting what she deserves. So that other remedy would be just to don't devalue the property. If there are no more questions, I yield the rest of my time, Your Honor.
Thank you. Mr. Starr, Ms. Lee, we very much appreciate your arguments, and we will take this matter under advisement. This time, we'll take a brief recess to reconstitute the court, and when we return, we'll hear the case of PC Riverview, the PC Riverview case. Thank you.